Hello again, and welcome to more of the exciting modern American remedies, cases, and materials. Today, we are reading about substantive policy goals as related to limits on damages as remedies in American law. The first case for today is Brunswick Corp versus Pueblo Bolomat, 429 U.S. Supreme Court 477, a 1977 case. Justice John Marshall delivered the opinion of the court. 1. Petitioner is one of the two largest manufacturers of bowling equipment in the United States. Respondents are 3 of 10 bowling centers owned by Treadway companies. Since 1965, Petitioner has acquired and operated a large number of bowling centers, including 6 in the markets which respondents operate. Respondents initiated this claim of this action, contending that these acquisitions violated various provisions of antitrust laws. In the late 1950s, the bowling industry expanded rapidly, and the petitioner's sales of lanes, automatic pin setters, and ancillary equipment rose accordingly. Since this equipment requires a major capital expenditure, $12,600 for each lane and pin setter, most of the petitioner's sales were for secured credit. In the early 1960s, the bowling industry went into a sharp decline. Petitioner experienced great difficulty in collecting money owed to it. By the end of 1964, over $100 million, or more than 25% of petitioners' accounts, were more than 90 days delinquent. Repossessions rose dramatically, but attempts to sell or lease the repossessed equipment met only limited success. To meet this difficulty, petitioner began acquiring and operating defaulting bowling centers when their equipment could not be resold, as a positive cash flow could be expected from operating the centers. During the 7 years preceding the trial in the case, petitioner acquired 222 centers, 54 of which it either disposed of or closed. These acquisitions made petitioner by far the largest operator of bowling centers, with over 5 times as many centers as its next largest competitor. Petitioner's net worth in 1965 was more than 8 times greater, and its gross revenue more than 7 times greater than the total for the 11 next largest bowling chains. Nevertheless, petitioner controlled only 2% of the bowling centers in the United States. At issue here are acquisitions by petitioner in the 3 markets in which respondents are located: Pueblo, Colorado, Poughkeepsie, New York, and Paramus, New Jersey. Respondents initiated this action in June 1966, alleging that these acquisitions might substantially lessen competition or tend to create a monopoly in violation of Section 7 of the Clayton Article 15 U.S.C. Section 18. Respondents sought damages pursuant to Section 4 of the Act, 15 U.S.C. Section 15, for 3 times the reasonably expectable profits to be made by respondents from operating their bowling centers. Respondents also sought divestiture order, an injunction against future acquisitions, and such other further and different relief as might be appropriate under Article 6, Section 16 of the Act and 15 U.S.C. Section 26. To establish a Section 7 violation, respondents sought to prove that because of its size, petitioner had the capacity to lessen competition in the markets it had entered by driving smaller competitors out of business. To establish damages, respondents attempted to show that had petitioner allowed the defaulting centers to close, respondents' profits would have increased. The jury returned a verdict in favor of respondents in the amount of $2,358,030, which represented the minimum estimate by respondents of the additional income they would have realized had the acquired centers been closed. As required by law, the district court trebled the damages. It also awarded respondents costs and attorney's fees totaling $446,977.32. And, sitting as a court of equity, it ordered the petitioner to divest itself of all the centers involved here. 39 F. Sup. 996, District of New Jersey, 1974. Petitioner has appealed. The Court of Appeals, while endorsing the legal theories upon which respondents' claim was based, reversed the judgment and remanded the case for further proceedings. That was a Third Circuit case in 1975. The court decided that the jury had not been properly charged and that therefore a new trial was required. It also decided that the jury verdict on Section 7 claim, the equitable decree, should be vacated as well. And it concluded that in any event, equitable relief should be restricted to preventing those practices by which deep pocket market entrant harms competition. Divestiture was simply inappropriate. Both sides petitioned this court for writs of certiorari. We granted Brunswick's petition. The issue for decision is a narrow one. Petitioner does not presently contest the Court of Appeals' conclusion that a properly instructed jury could have found the acquisitions unlawful. Nor does petitioner challenge the Court of Appeals' determination that the evidence would support a finding that had petitioner not acquired these centers, they would have gone out of business and respondents' income would have increased. Petitioner questions only whether antitrust damages are available where the sole injury alleged is that competitors were continued in business, thereby denying respondents an anticipated increase in their market shares. To answer that question, it is necessary to examine the anti-merger and treble damage provisions of the Clayton Act, Section 7 of the Act, proscribes mergers who affect may be substantively to lessen competition or to tend to create a monopoly, emphasis added. It is, as we have observed many times, a prophylactic measure intended primarily to arrest apprehended consequences of intercorporate relationships before those relationships can work their evil. United States versus E.I. DuPont de Normus and Company, 353, United States Supreme Court at 586 and 597, a 1957 case. Section 4, in contrast, is the essence of the remedial provision. It provides treble damages to any person who shall be injured in his business or property by reason of anything forbidden in the antitrust laws. Of course, treble damages also play an important role in penalizing wrongdoers and deterring wrongdoing, as if we have frequently observed. It nevertheless is true that the treble damage provision, which makes awards available to only injured parties, and measure the awards by a multiple of the injury actually proved, is designed primarily as a remedy. I don't know how to make anybody a moderator. I don't know how to do that shit. Nope. What wasn't it? Nope. Don't know. Oh, okay. There you go. Cool. You're a moderator. Stop. You're the highest level of moderator. Congratulations. Intermeshing a statutory prohibition against acts that have a potential to cause certain harms with a damages action intended to remedy those harms is not without difficulty. Plainly, to recover damages, respondents must prove more than that petitioner violated Section 7, since such proof establishes only that injury may result. Respondents contend that the only additional element they need to prove or demonstrate is that they are in a worse position than they would have been had petitioner not committed those acts. The Court of Appeals agreed, holding that compensable any loss causally linked to the mere presence of the violation in the market. Because this holding divorces antitrust recovery from the purpose of the antitrust laws without a clear statutory command to do so, we cannot agree with it. Every merger of two existing entities into one, whether lawful or unlawful, has the potential for producing economic readjustments that adversely affect some persons. But Congress has not condemned mergers on that account. It has condemned them only when they may produce an anti-competitive effect. Yet under the Court of Appeals holding, once a merger is found to violate Section 7, all dislocations caused by the merger are actionable, regardless of whether those dislocations have anything to do with the reason the merger was condemned. This holding would make Section 4 recovery entirely fortuitous and would authorize damages for losses which are of no concern to antitrust laws. Both of these consequences are well illustrated by the facts of the case. If the acquisitions here were unlawful, it is because they brought a deep-pocket parent into a market of pygmies. Yet respondent's injury, the loss of income that would have occurred, had the acquired centers gone bankrupt, bears no relationship to the size of either acquiring company or its competitors. Respondents would have suffered the identical loss, but no compensable injury, had the acquired centers instead obtained refinancing or been purchased by a shallow pocket parent, as the Court of Appeals itself acknowledged. Footnote 12. Conversely, had petitioner acquired thriving centers, acquisitions are at least as violative of Section 7 as the instant acquisitions, respondents would not have lost any income than they otherwise would have received. Thus, respondent's injury was not the type the statute was intended to forestall. Wyandotte Company versus United States, a 1967 case, Supreme Court. But the antitrust laws are not merely indifferent to the injury claimed here. At base, respondents complained that by acquiring the failing centers, petitioner preserved competition, thereby depriving respondents of benefits of increased concentration. These damages respondents obtained are designed to provide them with profits they would have realized had competition been reduced. The antitrust laws, however, were enacted for the protection of competition, not competitors. Brown Shoe Company versus U.S. Supreme Court case 1962. It is inimical to the purpose of these laws to award damages for the type of injury claimed here. Of course, Congress is free, if it desires, to mandate damage awards for all dislocations caused by unlawful mergers, despite the particular consequences of doing so. But because of these consequences, we should insist upon a clear expression of a congressional purpose. Hawaii versus Standard Oil Company, 405 United States Supreme Court, 1972. Before attributing such an intent to Congress, we can find no such expression in either the language or the legislative history of Section 4. On the contrary, it is far from clear that the loss of windfall profits that would have accrued had the acquired centers failed even constitutes an injury within the meaning of Section 4. And it is quite clear that if the respondents were injured, it was not by reason of anything forbidden by antitrust laws. Where respondents' loss occurred by reason of the lawful acquisitions, it did not occur by reason of that which made the acquisitions unlawful. We therefore hold that for plaintiffs to recover treble damages on account of a Section 7 violation, they must prove more than injury causally linked to an illegal presence in the market. Plaintiffs must prove antitrust injury, which is to say, injury of the type the antitrust laws were intended to prevent, and that flow from that which make the defendant's acts unlawful. The injury should reflect the anti-competitive effect either of the violation or of the anti-competitive acts made possible by the violation. It should, in short, be the type of loss that the claimed violations would likely cause. Zenith Radio Corp versus Hazeltime Research Inc., Supreme Court decision 1969. 3. We come then to the question of appropriate disposition of this case. At the What's the fun? That's funny. Funny, thank you, Mod. At the very least, petitioner is entitled to a new trial, not only because of the instructional errors noted by the Court of Appeals that are not at issue here, but also because the district court's instruction as to the basis for damages was inconsistent with their holdings as outlined above. Our review of the record, however, persuades us that a new trial on the damages claim is unwarranted. Respondents based their case solely on their novel damages theory, which we have rejected. While they have produced some conclusory testimony suggesting that in operating the acquired centers, petitioner abused its deep pocket by engaging in anti-competitive conduct, they made no attempt to prove that they had lost any income as a result of such predation. Rather, their entire proof of damages was based on their claim to profits that would have been earned had the acquired centers closed. Since respondents did not prove any cognizable damages and have not offered any justification for allowing respondents after 2 trials and over 10 years of litigation, yet a third opportunity to do so, it follows that petitioner is entitled, and a court with this motion may pursuant to Rule 50B, to judgment on the damage claims notwithstanding the verdict. Respondents' complaint also prayed for equitable relief, and the Court of Appeals held that if respondents established a Section 7 violation, they might be entitled to an injunction against those practices by which a deep pocket market entrant harms competition. Because petitioner has not contested this holding, respondents remain free on remand to seek such a decree. The judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion. There you go. That was Brunswick Corp versus Pueblo Bolo Mart. Our second and final case for tonight, it's a doozy. It's Bigelow versus RKO Radio Pictures, United States Supreme Court case, 1946. Yep, Bigelow versus RKO Radio Pictures. Chief Justice Stone delivered the opinion of the court. Chief Justice of the Supreme Court Stone. Petitioners brought the suit in the District Court for Northern Illinois under subsection 1, 2, and 7 of the Sherman Antitrust Act and subsection 4 and 16 of the Clayton Act for an injunction and to recover treble damages. Petitioners, who are owners of Jackson Park Motion Picture Theater in Chicago, alleged that respondents entered into a conspiracy which continued from some date prior to November 1st, 1936, to the date the suit was brought, July 28th, 1942, pursuant to which film was distributed among moving picture theaters in the Chicago district in such a manner that theaters owned by some of the conspirators were enabled to secure and show feature pictures in the advance of independent exhibitors not affiliated with the respondents, such as the petitioners. Petitioners charged that in consequence they had been subjected to a loss of earnings in the excess of $120,000 in the 5-year period from July 27th, 1937 to July 27th, 1942. Hey, moderator, look up what $120,000 in 1937 money is worth today. The matter of the injunction was reversed, and the case was sent to trial solely on the question of damages. The jury returned a verdict for $120,000 in petitioner's favor. The trial court gave judgment for treble that amount as prescribed by Section 4 of the Clayton Act. The Circuit Court of Appeals reversed on the sole ground that the evidence of damage was not sufficient for submission to the jury and directed the entry of a judgment for respondents not abstentio verdicti, notwithstanding the verdict. Seventh Circuit Federal Case, 1945. Petitioners have been since November 1st, 1936, the owners in partnership of the Jackson Park Theater, located on the south side of Chicago. Respondents RKO Radio Pictures Incorporated, Lowe's Incorporated, 20th Century Fox Film Corporation, Paramount Pictures Incorporated, and Vitagraph Incorporated are distributors of motion picture films. Respondent Balaban and Katz Corporation is a motion picture exhibitor, which operates a chain of some 50 theaters in Chicago and its suburbs, including the Maryland Theater and others on the south side of Chicago, which compete with the petitioner's Jackson Park Theater. Balaban and Katz is a subsidiary of Paramount. Each of the other distributors, movie studios, also own multiple exhibitors, movie theaters in Chicago. All right, there you go. So it's a little bit more than 120,000 sounds, huh? Rental contractors. So everyone out there in TV land, it was 120,000 in 1937 is apparently worth 534,000 today. Rental contracts between distributors and exhibitors undertake to furnish films to the exhibitors for stipulated rentals. In Chicago, these contracts uniformly provide the larger theaters in the Chicago Loop, downtown Chicago, all leased or operated by one of the more of the respondents, shall have the right to the first run of the motion picture distributed by the respondents for 1 week or such longer period as they may desire to exhibit them. Following the first run, the motion picture may not be shown in any Chicago theater outside the Loop for 3 weeks, a period known as clearance. In the 4th week following the end of the Loop run, the film was released for exhibition in theaters outside of the Loop for successive runs in various theaters for periods known as the A, B, and C pre-release weeks, followed by weeks of general release. There was evidence that respondent distributors and exhibitors conspired to give the distributor-controlled or affiliated theaters preferential playing positions in the release system, with the result that petitioner's theater was unable to obtain feature films until the first week of the general release, or 10 weeks after the end of the Loop release. By that time, most of the respondent exhibitor theaters, with several of which petitioner's theaters competes and which enjoyed the prior A, B, and C pre-release runs, had finished their showings. Regardless of the price offered for rental of film, the respondent exhibitors, distributors apparently intended, in the execution of the conspiracy, refused to release films to petitioner's theater except for the first weeks of the general release. 2 classes of evidence were introduced by petitioners to establish their damage. One was a comparison of earnings during the 5-year period of petitioner's Jackson Park Theater with the same earning of competitor Maryland Theater. The two being comparable in size, the Jackson Park being superior in location, equipment, and attractiveness to patrons. Under the discriminatory release system, the Maryland had been allowed to exhibit pictures in the C pre-release run 1 week ahead of petitioner's first week of general release. The evidence showed that during the 5-year period, Maryland's next receipts after deducting film rentals paid to distributors exceeded petitioner's likely receipts by $115,982.34. The second was a comparison of petitioner's receipts from the operation of the Jackson Park Theater less cost of film for the 5-year period following July 1937 with the corresponding receipts from the 4 years immediately preceding. After making allowance for the elements of a bank night receipts, the comparison shows a falling off of petitioner's receipts during the 5-year period aggregating another $125,659, which is more than $5,000 in excess of the $120,000 of damage demanded by petitioner's complaint. The significance of the comparison lies in the fact that during most of the 4-year period, and despite the operation of the release system as described, petitioner's theater had been able to procure some films which had not already been shown in respondents' theaters, whereas petitioners were not able to procure such films during the 5-year period which follows. Whereas petitioners were not able to procure such films in the 5-year period that followed, although there is evidence they made diligent efforts to do so. The change is attributable to the introduction of the practice of double features, the showing of 2 films at a single performance in theaters throughout the Chicago district. The evidence tended to show that when single features were being shown, exhibitors who had playing positions ahead of the petitioners did not exhibit all the films distributed, so that despite their inferior playing position, petitioners were able to exhibit pictures which had not been seen elsewhere. With the advent of double featuring, theaters with playing positions ahead of petitioners used nearly all the films distributed, and the pictures which petitioners were able to exhibit the first week of general release, by reason for the distribution system, had priorly been shown in nearly every case. The Circuit Court of Appeals concluded that the jury accepted the comparison of plaintiff's earnings before and after the adoption of double billing as established measure of petitioner's damage, but it held that this proof did not furnish a proper measure of damage for that reason, that while the petitioner's earnings were known and proved for both the 4- and 5-year periods in question, it could not be proved what their earnings would have been during the 5-year period in the absence of the illegal distribution of films. It thought that the mere fact that earnings in the Jackson Park Theater were greater before the adoption of double billing did not serve to show what petitioner's earnings would have been afterwards in absence of the release system. Similarly, the Court of Appeals rejected the comparison between petitioner's receipts and those of the Maryland Theater during the 5 years in question, since, as it thought, the comparison would not tend to prove what the earnings of either theater would have been during the critical period under any system other than that which is a product of the unlawful conspiracy. Upon the record in this case, it is indisputable that the jury could have found that during the period in question, a first or prior run theater possessed a competitive advantage over later run theaters because of its greater capacity to attract patronage to pictures which had not been shown elsewhere, and its ability to charge higher admission prices than subsequent run theaters, and that, other things being equal, the establishment of the discriminatory release system was damaging to the petitioners, who were relegated by it to playing a position inferior to that of their competitors. Each of the 2 classes of evidence introduced by petitioners tends to show damage, that they were not mutually exclusive, as the courts below seem to have thought, since each independently of the other tend to show that petitioners' inability to obtain films for exhibition before they had been shown elsewhere adversely affected their receipts. In the one case, by showing those receipts decreased when petitioners could no longer purchase films following the introduction of double features, and in the other, that petitioners' receipts from its theater were less substantially the same amount than receipts of its competitor, the prior run Maryland Theater, operating under conditions in other respects less favorable to those affecting petitioners. Respondent's argument is that notwithstanding the force of this evidence, it is impossible to establish any measure of damage because the unlawful system which respondents had created has precluded petitioners from showing other conditions affecting profits would have continued without change unfavorable to them during the critical period of that system had not been established, and petitioners had conducted their business in a free and competitive market. When petitioners acquired their theater, it was possible for them to secure films which had not had prior showing and to exhibit them in competition with theaters having preferred playing positions. Whatever restraints respondents' distribution system may then have imposed, and whether the later adopted practice of showing double features was or was not itself a product of unlawful conspiracy, petitioners were entitled to, as a right, to continue to purchase and show films which had not had prior showings free of the restraints of unlawful distribution system. The fair value of petitioners' right thus to continue their business depended on its capacity to make profits, and a fair measure of the damage to that right by respondents' unlawful distribution system was a loss of petitioners' admission receipts resulting from the application of that system to the petitioners. Respondents' only answer is that without the conspiracy, the conditions of purchase of films might not have been the same as they were before July 1937. That in any case, it is not possible to say what those conditions would have been if the restraints had not been imposed, and that those conditions cannot be ascertained because respondents have not removed that restraint. Hence, it is said petitioners' evidence does not establish a fact of damage, and further, the standard of comparison which the evidence sets up is too speculative and too uncertain to afford an accurate measure of the amount of the damage. The case in these respects is comparable to Eastman Kodak Company versus Southern Photo Company, 2S US 237 United States Supreme Court 1927 case, and to Story Parchment Company versus Patterson Company, a 1931 Supreme Court case, in which precisely the same arguments now addressed to us were rejected. In each case, we held that the evidence sustained verdicts for the plaintiffs, and that the absence of more precise proof the jury could conclude as a matter of just and reasonable inference from the proof of the defendant's wrongful acts and their tendency to injure plaintiffs' businesses, and from the evidence of the decline in prices, profits, and values not shown to be attributable to other causes, that the defendant's wrongful acts had caused the damage to the plaintiffs. In this, we but followed a well-settled principle. The tortious actions that had in each case precluded ascertainment of the amount of damages more precisely by comparison to profits, prices, and values affected by the conspiracy with what they would have been in its absence under freely competitive conditions. Nevertheless, we held the jury could return a verdict for the plaintiffs, even though damages could not be measured with the exactness which would have otherwise been possible. In such a case, where the defendant, by his own wrong, has prevented a more precise computation, the jury may not render a verdict based on speculation or based on relevant data, and rendered it verdict accordingly. In such circumstances, juries are allowed to act upon probable and inferential as well as direct and positive proof. Story Parchment, Supreme Court at pages 561 through 564. Any other rule would enable the wrongdoer to profit by his wrongdoing at the expense of his victim. It would be an inducement to make wrongdoing so effective and complete in every case as to preclude any recovery, by rendering the measure of damages uncertain. Failure to apply it would mean that the more grievous the wrong done, the less likelihood there would be of any recovery. The most elementary conception of justice and public policy require that the wrongdoer shall bear the risk of the uncertainty which his own wrongdoing has created. This principle is an ancient one and is not restricted to proof of damage in antitrust suits, although their character is such as frequently called for its application. In cases where a wrongdoer has incorporated the subject of a plaintiff's patent or trademark into a single product to which the defendant has contributed all other elements of value or utility, and derived profits from the sale of the product, this court has sustained recovery for the full amount of defendant's profits, where his own wrongful action has made it impossible for a plaintiff to show what proportions he and defendant should have contributed to the profits. The constant tendency of the courts is to find some way in which damages can be awarded where a wrong has been done. Difficulty of ascertainment is no longer confused with the right to recovery for a proven invasion of the plaintiff's rights. From Story Parchment. The evidence here was ample to support a just and reasonable inference that petitioners were damaged by respondents' action, whose unlawfulness the jury has found and respondents do not challenge. The comparison of petitioners' receipts before and after respondents' unlawful action impinged upon the petitioners' businesses afford a sufficient basis for the jury's computation of the damage, where the respondents' wrongful action had prevented petitioners from making any more precise proof of the amount of the damages. The judgment of the district court below will be affirmed and the judgment of the Court of Appeals reversed. Justice Jackson took no part in the consideration of this case. There we go. Thanks, babe. Justice Frankfurter's dissenting opinion. Our real question is whether the respondent's violation of the Sherman Law illegally injured their petitioners. This necessarily involves substantial proof that the petitioner's business would have been made more profitable if the distribution of movie films in Chicago had been a free-for-all, and no factor of the scheme that constituted an illegal conspiracy had been in operation, than it was under the conditions that actually prevailed. The record appears devoid of proof of that. If competitive conditions had prevailed, distributors would not have made rental contracts with their respective exhibiting affiliates to the serious disadvantages of independents like the petitioners. They might individually have done so and not have offended the Sherman Law. I agree that Eastman Kodak and Story Parchment should guide the disposition of this case, but I do not find that the decisive distinction made in those cases has been observed in deciding this case. The distinction is between proving that some damages were the certain result of the wrong and uncertainty as to the dollars and cents value of such injuring wrong. Such difficulty in ascertaining the exact amount of damage is a risk properly cast upon the wrongdoing defendant. But proof of the legal injury, which is the basis of his suit, is plaintiff's burden. He does not establish it merely by proving that there was a wrong to the public, nor by showing that if he had been injured, ascertainment of the exact amount of damage would have had an inevitable speculative amount to be left to a jury's conscious guess. This basic distinction was thus formulated in Story Parchment. Quote, the rule which precludes the recovery of uncertain damages applies to such as are not the certain result of the wrong, not to those damages which are definitely attributable to the wrong and only uncertain with respect to their amount. Quoting Story Parchment again. In Eastman and Story Parchment cases, the plaintiffs established what their profit was when competitive conditions prevailed, and that the subsequent loss properly became exclusively attributable to the restraint of such conditions. Such comparison is not revealed by this record. It was wholly speculative, as the Circuit Court of Appeals properly held, in applying the rule of the Story Parchment case, whether the intake of petitioners would have been more profitable if the distribution of films in Chicago had been left wholly to the haggling of a free market. Double check. Yep. That's the end of the cases for today. So stand by next week for getting into taxes, time, and the value of money, starting with Norfolk versus Western Railway, or Norfolk and Western Railway versus Lepelt, 1980 Supreme Court case. All right, everybody out there in YouTube land, y'all have a good one. Enjoy your modern American remedies, and have a good night. God bless y'all.